Welcome to the Ohio Eviction Playbook.
Hey everyone, welcome into an all-new episode of the Ohio Eviction Playbook with attorney Ed Kasputis. I'm your host, Mike Leon. You know, Ed here is a longtime Ohio attorney. He's a former state legislator, and he's the founder of, obviously, the Kasputis law firm. He approaches these evictions through both a legal and a business lens, helping landlords and investors avoid costly mistakes. We're going to try to save them from those costly mistakes in today's episode, because we're going to be talking about how subsidized evictions actually work in the state of Ohio, additional notices, court programs, all the issues landlords need to account for. Ed, it's good to see you as always. So at a high level, let me ask you, how does the eviction process kind of differ in the state of Ohio when a tenant is in subsidized housing compared to, like we talked about in the last episode, like a standard market eviction, for lack of a better term?
Yeah, thank you very much, Mike, for having me on. When we evict someone who's receiving Section 8 or Eden, there's a bunch of more hoops to jump through. You know, in our previous podcast, if it's not subsidized housing, you're only using state forms and following state law. But if it's subsidized housing, you've got to jump through some extra hoops, and it takes longer. In fact, things have just changed dramatically in the Cleveland Municipal Court, who started to require additional federal forms that everybody, including me, had no idea of 2-3 weeks ago. So let's say you have a Section 8 tenant and their rent's $1,000, they have to pay $100, and Section 8's paying $900, and they're just not paying. There's many times when someone will come to me and I'll say, all right, we got to jump through a lot of hoops. Let's be practical. When does their lease up? In 2 months. All right, give them notice that you're not renewing and keep taking $900. But let's say it's vice versa. Section 8's paying $100 and the tenant's not paying $900. What do we got to do? Well, since COVID, the federal government requires you to give a 30-day federal notice called the CARES Act notice, saying if you haven't paid your rent, you have 30 days to pay it. Then, if you don't pay it, then we'll give you a 3-day state notice, and we will then sue you for eviction. Well, a few weeks ago, the Cleveland Municipal Court ruled, hey, no, there's a couple federal HUD forms, HUD Form 5380 and HUD Form 5382. Anytime you want to terminate a tenancy, you have to give those two forms with your other notice. So let's say you're doing a CARES Act notice, you haven't paid your rent. Now you have to give 3 forms. The last 2 forms deal with domestic violence, and it's counterintuitive. You're evicting them for non-payment. It has nothing to do with domestic violence, but the Code of Federal Regulations says, no, you have to give it to anyone that's getting subsidized housing. So I've been holding the hands of many clients now, and they're just frustrated that it takes so long to do. Now, in Northeast Ohio, so far, Cleveland Municipal Court is the only court that's requiring these forms, but I warn everybody, all the courts will start to follow it now that the genie is out of the bottle. And how did we all discover this? Buried in the Code of Federal Regulations? Thank you, Cleveland Legal Aid Society, for writing a brief and educating everybody, including the court, that we have to kill more trees now in order to get rid or to evict subsidized tenants.
Well, we don't have to kill trees here because it's a podcast. Let me ask you, I want to expand on that. So the required 30-day notice period expires in this subsidized eviction. Repeat again, what were the additional notices and forms that got to be served if the tenant hasn't paid or vacated?
It's HUD Form 5380 and HUD Form 5382. And for our clients, I mean, we'll send that to them. We will hold their hand and help them do that. But I mean, like I said, a couple weeks ago, this is all news to me, and I can at least say I have the most current HUD forms, but a lot of trees are going to get slayed. So let's say you want to end their tenancy. Then you can give a normal letter saying I'm ending your tenancy, but here is HUD Form 5380 and HUD Form 5382. And when we file the eviction, I will attach those 2 HUD forms also to the complaint. Then, if they don't leave and we have to serve a 3-day notice, again, I have to attach those two HUD forms. So now the complaints will be big, but I guess pursuant to the Code of Federal Regulations, we're protecting their rights.
There's an 8675309 joke in there somewhere, Ed. Let me ask you, what happens to a tenant's housing subsidy if they are evicted from the subsidy? You kind of gave the math earlier, but what happens to that if they're evicted from it?
If they're evicted from it, they can forever lose their right to be, on Section 8 or be on Eden. Now, from a practical matter, Cleveland Municipal Court. The Cleveland Municipal Court has a mediation program. And if the judge was here, I'd twist her arm and say, tell the real reason. And the real reason is, under the mediation program, if they agree to vacate and they honor when they have to vacate, there won't be an eviction on their record. So that is a creative way so that someone does not forever lose their housing voucher. But let's say they agree to be out by February 25th and they violate that. Typically, we have a status hearing like the next day or 2 days later. And then we tell the judge the person's not left. We want an eviction. They will grant the eviction. But the Cleveland mediation program is an attempt to not be as draconian as you have forever lost your housing assistance.
Ed, can we expand on the program for a second? Because I know there's guidelines within the mediation program. So, like, what are some other reasons that a landlord might choose the mediation route instead of just proceeding directly with an eviction?
Well, number one, you'll get a speech from the Cleveland Municipal Court saying they have a strong mediation program. And it's like, all right, I get the hint. We'll go into that. But number two, there's times where I might discover that there's something defective with the landlord's paperwork. And the one creative way to get around the landlord's paperwork is, okay, we'll do a mediation. And there are times I've had cases where I'm telling a landlord, listen, your paperwork's not perfect. Something changed or whatever. And we can give them a little extra time to get out, because if we got to start the whole process over with better paperwork, that'll be another 5-6 weeks. So sometimes the mediation program can be a win-win where the tenant gets a little extra time. From a practical standpoint, there's times when people say, hey, I'm getting a tax refund. I can start making catch-up payments. So what do we do in the mediation program? We create a payment schedule. And if you miss a payment schedule, you're evicted. You'll have a status hearing and evicted. So there are times during COVID, and there was government benefits. I had 2 or 3 landlords where I got like $20,000 of federal money to keep the tenant in their home. And they're like, hey, Ed, I hired you to evict. Thank you. Now I get to go to Red Lobster.
Ed, can I ask you, we talked about this in a previous episode about legal aid, but can I ask you to explain the Cleveland Municipal Court Right to Counsel program, how that operates, and what has to occur for legal aid to kind of become involved?
In the Cleveland Municipal Court, there's a Right to Counsel program where I believe both the city of Cleveland and United Way throw money in, and they pay legal aid to represent people who have minor children in order to slow down the eviction process. So if we're in the Cleveland Municipal Court, one of the first things that will happen when they call the case is that they will ask the defendant, do you have any minor children? And if they say they do, they'll put them in a Zoom breakout room. That's another benefit. Cleveland Municipal Court meets through Zoom, which is very efficient from my practical standpoint. So then they'll get screened by legal aid, and if they have minor children, they'll come back from the breakout room and say, yeah, legal aid has agreed to take my case. And then the court will give a 1-week continuance for the defendant to meet with legal aid. And, many times it's a blessing when legal aid gets involved. It's like the landlord's attorney and the legal aid attorney, they can talk like the dolphin talk. They can communicate in 2 minutes what it might take regular people to communicate in 20 minutes, and they can find a resolution. During the days of COVID, Cleveland Legal Aid was excellent at finding financial money from the government. They're like a financial aid counselor, so that if there was any money to be had, they would know, and they know the scuttlebutt. Like, this program just ran out of money, but this program just got funded. and they were pretty effective in helping their clients get financial aid.
Ed, we talked about this in a previous episode about month-to-month Tennessee and Ohio and evictions around that. But let's say the landlord wants to end the month-to-month in Ohio. Like, what kind of notice is required around that? How does that process change if the tenant doesn't vacate after the notice period ends?
Well, the 30-day notice, unlike the 3-day notice, can just be a letter. Dear tenant, please be advised I'm ending your month-to-month tenancy. February or March will be your last month. And then if they don't leave, then you start the process of giving them a 3-day notice saying you're being evicted because your lease has expired.
Ed, as we put a bow on today's episode, everything we've talked about today, what are some other common eviction mistakes that landlords have made in these situations based on everything we've discussed today and your years of experience doing this?
I think, I used to own a 244 unit apartment community. Tenant screening is number one because you're extending credit and you got to wisely do it. So what I'm seeing is that the smaller, unsophisticated landlords are not properly screening their tenants, both on financial ability to pay and criminal background. So a lot of times they'll come to me and they need to evict somebody, and I'm like, what do you know about them? Not much. And it's like, well, it's like you're an easy dater. That's not good. You got to figure it out. Once you determine that, the next thing is just a business consideration. I'll have people that'll say, I want to evict this person. Section 8 pays $900 and they pay $100. Okay. And what month is it? December. Okay. If you evict them in December, is there a good chance that you'll be vacant January, February, March? Yeah. Okay. Well, let's think as a businessman. Do you want $900 a month during the winter, or do you want Texas justice where you get rid of them today? Let's think it through. There's many times I will talk as a businessman and slow down what the landlord wants to do because of business considerations. So many times good business and the law intersect, and you got to decide, what am I going to be today? A good businessman, or I'm going to follow the letter of the law and maybe cut my nose off.
Yeah. Cut your nose off to spite your face. Can't do it, Ed. Ed, thank you so much for the time, the insights, and breaking this all down. I appreciate it as always.
Thank you.
And that's it for today's episode of the Ohio Eviction Playbook. If you want to learn more about Ed's work and all he does helping landlords and real estate investors really navigate these complex Ohio eviction issues, do me a favor right now. Visit KasputisLaw.com. Before you go as well, do me a favor, like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.